as an effort at basically agency capture at the Supreme Court level. We have to be very careful about this, Mr. President. And with that, I'll yield to my distinguished colleague from Hawaii.
Senator from Hawaii.
Mr. President, I thank my colleague from Rhode Island, the senator from Rhode Island. Mr. President, in Hawaii, we understand the importance of caring for our planet. The Native Hawaiian community embraced the idea of malama aina, a respect and responsibility to care for the land in a way that protects our environment for future generations. That's why Hawaii has led the way in enacting measures to fight climate change and safeguard our natural resources. In the last few years alone, Hawaii set ambitious goals to move to 100% renewable energy and become carbon neutral. We were the first state in the country to commit to meeting the objectives of the Paris Climate Agreement. In contrast, the Trump administration has spent the last year and a half disparaging the idea of protecting our land and natural resources. Donald Trump has taken action after action to prioritize the interests of his supporters in the fossil fuel industry at the expense of our environment. The president filled his administration with appointees who refused to accept the realities of climate change. He named 2 Environmental Protection Agency administrators, Scott Pruitt and Andrew Wheeler, who don't even believe in the EPA's mission of protecting the air we breathe and the water we drink. And administration officials have weakened rules that regulate pollution and protections for our natural resources. These actions have led to lawsuits by groups who embrace malama aina and seek to protect our environment. These lawsuits will be decided by our courts. The outcomes will depend on an independent, fair, and unbiased judiciary. A number of these cases will come before the Supreme Court. In the October term, the court will be hearing a case called Weyerhaeuser Company v. U.S. Fish and Wildlife Service to decide whether the federal government can protect endangered species on private land. Cases making their way through the lower courts include California v. EPA, which challenges the federal government's regulations on vehicle emissions, and another case, West Virginia versus EPA, which challenges President Obama's Clean Power Plan. These cases raise crucial questions that will determine whether the government has the power to protect our environment. The answers to those questions may very well come from the Supreme Court. The president's nominee to the Supreme Court, Brett Kavanaugh, raises serious concerns about whether he would be that fair arbiter on environmental issues on these kinds of cases that will surely come before the Supreme Court. Throughout his time on the D.C. Circuit Court of Appeals, Judge Kavanaugh has argued for weakening environmental regulations, basically his decisions benefit industry over the environment. In Coalition for Responsible Regulation, Inc. versus EPA, Judge Kavanaugh argued that the EPA should not regulate greenhouse gases under the Clean Air Act because the cost of business was more important than protecting the environment and public health from climate change. He said that the EPA should not include greenhouse gases in the interpretation of the statute that says EPA can regulate any air pollutant because, as far as Judge Kavanaugh was concerned, such a requirement or such enabling the EPA to do that would result in higher costs for businesses. Judge Kavanaugh did not consider the cost to the environment. In Hawaii, we are already paying the price of climate change caused by greenhouse gases. Our coastlines are disappearing, corals in our oceans are dying, and catastrophic floods are becoming more frequent and more severe. The science behind the need to regulate greenhouse gases is clear. This message is lost on the president and apparently on Brett Kavanaugh, as he argued for a very limited interpretation of the EPA's authority to regulate. In another environmental case, Judge Kavanaugh sided with the fossil fuel industry in his dissent in White Stallion Energy Center versus EPA in 2014. There he argued that under the Clean Air Act, the EPA should not regulate toxic air pollutants from power plants without factoring in what those regulations would cost polluters. The majority disagreed with Judge Kavanaugh, saying the EPA's approach is clearly permissible, consistent with prior Supreme Court instruction, and consistent with the purpose of the legislation, which was, of course, to protect the environment and the health and safety of people. When the case went to the Supreme Court, then Justice Scalia quoted Judge Kavanaugh in his reversal. Judge Kavanaugh's opinion even went so far as to attempt to restrict the manufacture and sale of renewable fuel. In a 2012 case, Grocery Manufacturers Association v. EPA, Judge Kavanaugh opposed the EPA's grant of E15 waivers. These waivers would permit the manufacture and sale of a type of renewable fuel which would help our nation decrease its dependence on foreign oil. In his dissent, Judge Kavanaugh argued that the EPA's rule permitting this renewable fuel would in effect force the production of renewable fuel. There's nothing in the statute that talked about forcing anybody to do anything. Actually, the words in the statute is permit. Permitting is not the same as forcing. And of course, Judge Kavanaugh certainly knew the difference before taking a position that supported the fossil fuel industry. Judge Kavanaugh's record on these environmental issues make it highly unlikely, or highly likely, that as a Supreme Court justice, he would favor fossil fuel interests over human health, renewable energy, and protecting our planet.